Everything you need to know about products and services that can improve your life. This is Experts on Call on CL 650.
Welcome back to 650 CIL's Talk About Strata, and thank you, Dwayne, for that great little introduction, because we are talking about the Civil Resolution Tribunal and some of the issues that are going to be coming up in anticipation of the tribunal being implemented in the new year. And, you know, and as Veronica pointed out, that orders for stratas to deal with bylaw compliance are very costly, expensive, timely, and so the Civil Resolution Tribunal is going to provide strata corporations with a good alternative. It's going to be timely, it's going to be economic. Strata corporations won't be having to go to Supreme Court to be able to get orders for compliance with bylaws and issues, and that will make a big difference. But we have some voluntary issues that need to be dealt with, but there's still a good incentive for people to solve disputes early on. In the age restriction scenario that we talked about, Shannon, the issue was raised about discrimination around age and human rights. How would the Civil Resolution Tribunal interact with things like the Human Rights Tribunal or the Residential Tenancy Board?
Well, the Act is quite specific about the tribunal's jurisdiction over those matters. So in particular, the tribunal doesn't have jurisdiction where there's a conflict between the Human Rights Code and another act. So in this case, the Strata Property Act. Although in this case, in the scenario that your reader, or listener rather, sent in, it doesn't sound like there would be a conflict, because the Human Rights Code specifically says it doesn't apply to scenarios like the one in the letter. But even where there's no conflict, the tribunal can decline to apply the Human Rights Code in a dispute. So the Act has very clear provisions about that, and it also has provisions about its applicability to the residential tenancy branch, right, and certain orders under the Residential Tenancy Act.
Right.
Yeah.
Okay. So there'll be some boundaries, and obviously the tribunal then will be able to assess whether this is a matter that should be heard within the jurisdiction of the tribunal, or whether it's a matter that should go to another jurisdiction.
That's right. I mean, there's 27 tribunals in British Columbia, and sometimes an issue may on its face appear to belong within the scope of one tribunal, but really it belongs to another. And so it's a matter of looking at the facts, looking at the law, and determining what the appropriate forum is. And sometimes there's more than one forum, right, for a dispute.
Well, it's going to be a daunting task to put this together.
Well, you know firsthand, Tony, because you've been really helpful in volunteering some of your time and expertise with the Solution Explorer.
The Solution Explorer, for the listeners, is going to be, I think, an exceptional tool for people to help to understand what kind of dispute they have. What kind of steps they can take to try and resolve it before it goes any further, and give the parties the ability to come up to some resolution. So it certainly the development of that has been enlightening to everyone who's been involved.
Yeah, and for your listeners, the Solution Explorer will allow somebody who knows they have a problem but can't really put a name to it to better understand what their rights are under the applicable legislation, and to, as you say, get some tools, whether it's a template letter or a checklist, more information so that they understand their problem and they understand their options.
Well, Veronica, we have a strata who has been charging different owners different rates on strata fees, whether or not an owner has volunteered for work around the complex. And I'd like to say that this is a rare thing that happens, but we see people charged user fees because they're renting their unit, so the strata tries to charge them an extra $20 a month, or the owner themselves is on strata council and does a whole bunch of work, so the strata decides to waive their strata fees in exchange for that. Or in this case, we have a group of owners that are charged different rates because it's a small self-managed strata, and the strata says everybody has to do 20 hours of work on the complex a year, or you're going to pay more. So I'll just leave it up to you.
Big no-no? Can I just summarize that with that's a big no-no?
I knew what the answer was.
I knew that too. Yeah, that's just full of problems. Strata fees are calculated on the basis of unit entitlement. And if you want to deviate from unit entitlement, which is what they're doing by giving people breaks on strata fees, etc., then they've got to do that by unanimous vote resolution. So short of a unanimous vote resolution that allocates expenses in a different way than unit entitlement, they can't do this. I don't know how they can compel people to volunteer. And I mean, if it, to me, it sounds like what they're doing is paying people for services. So call it what it is and say that the Strata Corporation is going to pay your neighbor to do whatever it is, weeding of the gardens. And then they would get paid, and they would still pay the same amount of strata fees that they're supposed to be paid by unit entitlement. And they're, in essence, they're offsetting each other, but they still have to pay the correct amount of strata fees by unit entitlement.
I saw another one this week that just kind of made me scratch my head, but turns out it's not the only one, because it turns out that the source of information was an accounting office in the interior, but a strata was telling all their owners, if you pay all your strata fees up front at the beginning of the year, we will discount it by 5%.
And on what basis is that? I mean, there's
No
nothing
kidding.
under the act that would allow you to do that again.
Exactly, and which simply means that that owner would be short 5% of their strata fees, and which haven't been collected. There are no, that's your fee, that's your flat fee. The other thing that occurred was strata corporations who have bulk cable services, right? We have a very nice court decision from Supreme Court about this, and the strata corporation can deliver bulk cable services, but they need the authority from the owners to do it, which means a bylaw. But more importantly, it's based on unit entitlement. It's not something that's
not a flat fee.
It's not a flat fee that everybody pays, and we have stratas across the province who are doing this incorrectly, and they need to get it corrected. But Shannon, this also, it kind of focuses on the whole issue around money. And that's one of the significant things that the tribunal will be able to do with strata corporations and owners is address money issues.
Yeah, that's right. So as I said earlier, the tribunal will have quite a wide jurisdiction to order the strata corporation or an owner to do something or to stop doing something. And that certainly involves things like paying fines, paying penalties, monetary orders, with some exceptions. And as I said earlier, the tribunal can't make orders that deal with disposition of an interest in land. So can't order the winding up of a strata corporation or that sort of thing. But certainly things like bylaw enforcement, monetary orders with respect to the operations of the strata, that's something that the CRT will have jurisdiction over.
So that'll include things like insurance claim deductibles too. If there is a failure or a loss in a strata lot that an owner is responsible for, is there a limit then for strata disputes on value?
There isn't, and that's a good question. So for the small claims jurisdiction, it's $25,000 or less, which is the existing small claims jurisdiction at the small claims court. On the strata side, there isn't that limitation. And so we know that it's pretty easy to get past $25,000 for certain strata insurance or property claims.
Insurance deductibles of 50 or 100,000 are not that uncommon anymore. So the strata corporation, obviously the ability would be to get into a good dispute resolution process that would be expeditious and economic, provided the owner themselves actually consented at this point.
Right, and we've talked about the incentives at least for an owner to consent. And so hopefully that will be effective until, as I say, hopefully sometime in the future it will become mandatory.
That's interesting. Mm-hmm. So a lot of what the tribunal is going to be doing basically is problem solving then. That's the objective, is to try and get the parties to consensually resolve problems before they even require a decision.
That's right. And the way that we're designing that process on the facilitation side is to really just give the facilitator or case manager as much room as they need to work their magic. We know that facilitators are great at reading the parties, understanding the conflict, and figuring out a process and an approach that will work in the specific case. And that's a huge advantage or increase in service over existing dispute resolution mechanisms within the court. And I think you're right. You can people feel that they have more ownership over a solution that they've helped to craft. So
variable rates, fees, expenses, user fees, Veronica. The Strata Corporation at this point, the difficulty would be, and we could do this. Owners could petition for a special general meeting to say, hey, wait a minute, the Strata's not doing this right. But it still comes back to the principle that if the majority of the owners say, no, we agree, we're going to keep doing this, without an order from the courts or the tribunal, there's nothing that's going to compel this to change.
Absolutely. And that's why you see, despite being told by their property managers or by even their lawyers sometimes that they'll, they're doing flat rate gas charges, for example.
Yeah,
You know,
yeah.
and instead of because certain owners have fireplaces, they're charged a flat rate for their fireplace. It has absolutely no connection to how much they actually use gas. So yeah, you need a court order.
So strata corporations are going to find that all these quirky little formulas they've been doing that have been not compliant are suddenly going to be tested through the tribunal system, because that's going to be the easiest place for the tribunal system to go. One other question, though, for you, Veronica. Under the Strata Property Act, a strata corporation can have a bylaw that permits them to go to small claims court without the further need for a 3/4 vote.
Yes.
Now, we haven't seen a change in our legislation as to whether that same condition is going to apply to a CRT application.
Yeah, we don't. And if you look at the legislation, arbitration proceedings, which is an alternate dispute resolution, requires a 3/4 vote as well before you can initiate those proceedings. So arguably, you would need a 3/4 vote potentially to do the CRT.
So it'll be interesting to see how this test kind of works out as we move forward.
Yeah.
I'm Tony Giaventu. This is 650 Sea Isles Talk About Strata, and we'll be back in just a moment.
This is Experts on Call on Sea Isle 650.